Hello, my name is Kevin, and these are my partners Angelina, Hallie, and Serena. In this presentation, we aim to inform you about affirmative action, a policy in which resources are allocated favoring groups regarded as disadvantaged. Affirmative action is a critical topic that has been receiving more and more attention lately, practiced by universities and hiring programs around the globe.
The constitutional basis of affirmative action lies in the Equal Protection Clause of the 14th Amendment, prohibiting discrimination based on race, ethnicity, or gender. Supporters argue it promotes diversity of college campuses, and opponents claim it's reversed discrimination. Previous Supreme Court cases have allowed race based considerations only when they are narrowly tailored to achieve diversity.
The stance regarding affirmative action is currently ambiguous, but will hopefully be cleared up by upcoming Supreme Court cases. However, both lower and higher courts have ruled in the past that diversity was a compelling government interest, allowing race-conscious admission policies to promote diversity in college campuses and beyond. 9 states currently ban affirmative action in public universities.
SB 1 is the most important law regarding affirmative action. It was adopted from the Regents' Resolution and requires that race, religion, sex, color, ethnicity, and national origin are not to be considered in the admission decision process. It was assumed by the Board of Regents of the University of California in 1995 and was adopted due to the decline of certain ethnic groups of students, leaving UC to ban race or gender-based preferences in applications.
In 1965, President Lyndon B. Johnson passed Executive Order 11246, which prohibited employment discrimination based on race and background by organizations receiving federal contracts and subcontracts. 2 years later, the order was amended to include sex as well. Additionally, the executive order required federal contractors to take affirmative action to ensure equal opportunity be provided to all.
In the case of Regents of the University of California versus Bach, Bach accused UC Med School of racially discriminating against him in favor of lower performing minority applicants. The Supreme Court ruled that affirmative action was allowed, but only to promote diversity. For decades, this case set the precedent for subsequent affirmative action cases.
A poll sponsored by Inside Higher Ed shows that 74% of adults do not favor affirmative action and believe that race should not be considered when determining college applications. However, there's still a group that supports affirmative action because of the wrong contextualization when referring to this issue, because many people opposing affirmative action think considering race does not mean considering academics. Initially, China had affirmative action policies in hold to give advantages to smaller ethnic groups, because based on their national entrance examination scores alone, these groups of less advantaged people wouldn't be able to get into the colleges they hoped. However, these are currently seen as unfair benefits, and China abolished affirmative action, leading to more fair university acceptance and more equal policing. Affirmative action reached South Africa in 1994 after turning mostly Democratic, opting for change. There was significant bias against African, colored, and Indian people, with white people getting the most opportunities. Thus, the government changed the requirements to remove bias for race, leading to a more fair space for all citizens. While this affirmative action has gotten to most of the men and colored and Indian women, it's still striving to reach African women.
The American Civil Liberties Union has 1.8 million members that defend rights protected by the Constitution. This includes affirmative action. They believe these programs are used in situations where race and gender have to be taken into account for fair access to all. They state a report where white men make up 43% of a workforce but held 95% of senior management jobs. Students for Fair Admissions is a group of 20,000 like-minded people who believe affirmative action causes reverse discrimination, favoring specific ethnicities. They believe affirmative action violates the Equal Protection Clause of the 14th Amendment and Title VI of the Civil Rights Act of 1964, which doesn't allow racial discrimination at places that include private colleges. They've gone to court against Harvard, UNC, and the University of Texas. Mississippi, the most conservative state as of 2023, has universities that consider race in admissions but no affirmative action plans for employment. However, it does have a state non-discrimination law where military status is also considered a protected trait. Mississippi State University has an affirmative action plan that hopes to promote diversity in the workforce and applications.
California, a liberal state, has prohibited any form of affirmative action since 1996 under Proposition 209. This is quite interesting, as liberals tend to be supporters of affirmative action. California has tried to amend its diversity disparities through other means, but it struggled to achieve the same levels of diversity compared to other universities that use affirmative action.
Many alternatives or solutions have been proposed by those against affirmative action because they believe in a world with social equity where race does not have to be taken into consideration. Former Chief Justice John Roberts once said, "The way to stop discrimination on the basis of race is to stop discriminating on the basis of race." By admitting students based on merit, he believes things can be more fair.
The Supreme Court is set to hear Students for Fair Admissions versus Harvard and versus UNC this summer, cases alleging racial discrimination in university affirmative action programs. A ruling banning race considerations in college admissions could decrease diversity and would overturn the rulings of over 50 years of precedent cases.
Thank you for your time.